Good morning, everyone. Before we get started, I want to just do an audio and video test here from the courtroom for our colleague, Judge Rovner. Good morning, Judge Rovner. Can you hear and see us okay?
Perfectly, and you all look so good to me.
Okay.
All of you. That
do
includes the lawyers.
So with that, we'll call this morning's arguments. We have 6 cases scheduled for argument today. We'll begin in appeal number 20-3065, Soleimani Namaga versus Pamela Bondi, the Attorney General of the United States. And I can say for the 3rd through 6th cases that the court will take a short recess of 10 minutes after the second argument. So with that, the first argument is all remote. I see Mr. Yerman. Mr. Lafort, can you hear and see us okay in the courtroom?
Yes, Your Honor.
Mr. Yerman, how about yourself?
Yes, I can. Thank you.
Okay. Good morning to both of you. And Mr. Yerman, you may proceed when you're ready.
Good morning. May it please the court. Gary Yerman on behalf of the petitioner, Mr. Namaga. We believe the petitioner has met his burden to show that his failure to appear was due to exceptional circumstances under this court's analysis in Nazarova, where the court looked to the entire unfortunate chain of events being asserted. In absentia orders are used to punish those who intentionally evade their responsibilities of appearing before an immigration court. In absentia orders must be rescinded when a respondent can establish exceptional circumstances for missing their court. Under the totality of circumstances involved in this case, and I do not need to waste the court's time repeating the facts, exceptional circumstances have been established, along with the immediate relief of Mr. Namaga's U.S. citizen daughter's I-130 petition, which has now been approved, combined with his legal entry initially in 2000 as a student. We urge this court to grant the relief sought by the petitioner to reopen his case so that he may complete the process necessary to become a lawful permanent resident before an immigration judge.
Mr. Yerman, good morning.
Good morning.
You know, there was a 35-day period between the burglary and the court date during which Mr. Namaga could have made a new backup plan to get to Chicago or advise the immigration court of his situation. You know, even on the morning of the hearing, when his ride fell through, he could have called the court first. I really have sympathy for Mr. Namaga, but what I think we need to know is why no reasonable jurist could find that these circumstances do not rise to the level of exceptional, as we all know, are incredibly onerous.
Well, I thank you for that question, Your Honor. I think the only way we can do that would be by literally stepping into the shoes of Mr. Namaga during this particular time of his life, where he was destitute and the options were few, if any. And the one option that he thought was viable was a ride that was promised to him by his roommate. And there was no reason for him to doubt that promise. And again, once that promise was broken, what would a person with no education or experience in the law do under those circumstances, be it an American or a foreign national? They would contact the number, use a number that they thought was a number that was appropriate. And so he borrowed a phone, he tried to make the call, it didn't go through. So, under these circumstances, stepping in his shoes, he tried to get a ride, he tried to make the call, but they both failed. And would you or I have other options? Would most people have other options? Yes. But standing in Mr. Namaga's shoes in this particular circumstance, I think he tried to use the options that were available to him, but he failed.
I have been wondering about something, and I might very well have missed it. Um, my understanding was that the attorney had withdrawn, but it appears that the attorney was present at the October 1st hearing. Can you just help me with that?
Well, I can tell you that Mr. Namaga was placed in proceedings in 2010, and this hearing was 2019. So it seems apparent that he and his attorney had appeared at all previous hearings, but the attorney was the only one who showed up at the hearing because it's our responsibility to still go to court, to let the judge know, to make the request in court to withdraw his counsel, and then to let the court know that you have informed your client of the hearing date.
Sure.
That's why I assume he was here, and I assume that's what happened on that day.
I see.
Mr. Yerman, could I ask you to explain to us the practical side of the grant of Mr. Namaga's daughter's petition?
Sure.
How does that
Thank
affect
you
the
for that
case in
question.
front of us?
You must be eligible for a green card, and you must be admissible for a green card. His daughter is a U.S. citizen, 21 years or older. When that petition became approved, he became eligible for a green card. So the next question is he admissible? Well, that will be determined by an immigration judge. But first, you must look at the manner of entry. Did this person enter without inspection, or with a false document, or like Mr. Namaga, entered legally under a student visa? Because he entered legally, he's now admissible. So he has eligibility and admissibility.
So how does that affect this case in front of us?
Sure. Okay, so what will happen is if this court grants the petition and remands the case back to the immigration judge will decide two things. Will he decide the I-45, the application for a green card, and look at all the factors that need to be looked at? Or will he terminate the case and have USCIS decide whether the green card should be issued? My guess is, in this case, the judge in Chicago will keep the case, review all the facts to determine if Mr. Namaga is qualified to be approved to get a green card.
That's the optimistic view from your point of view.
It is.
And what
if
if
he's
we deny
not,
the
then
petition?
the judge will deny the 45,
What if
order
we,
him removed.
Mr. Yerman,
and-
Mr. Yerman,
Yes.
please. What if we deny the petition? What happens to the
Oh.
daughter's petition?
It basically will get vacated, and
Why is that?
well, he would have to return to Mali, and he would need a waiver to return. And having a U.S. citizen child does not qualify you for a waiver. You would need a U.S. citizen or green card holder spouse or parent. So there's no Plan B option.
So I want to make sure that I understand. So your point is if we were to reverse or vacate the order below, would that have the effect of rescinding the removal order?
Yes, it would. And it would go back in front of the immigration court. And the immigration court will look at all the factors, whether he's qualified to receive lawful permanent residence or not.
Okay.
He doesn't have a free golden ticket waiting for him. He must prove to an immigration court that he's qualified and meets all the requirements.
Mr. Yerman, you saved a little bit of time for rebuttal. We can reserve that remainder and go to Mr. Lafort if you prefer.
Thank you.
Okay. Mr. Lafort, good morning.
Good morning, Your Honor, and may it please the court, Dietz Lafort on behalf of the respondent in this particular case. The agency here properly exercises discretion in denying petitioner's motion to reopen because he failed to show his absence was due to exceptional circumstances. 8 U.S.C. 1229 alpha establishes a goalposts, a right and left goalposts regarding what should be characterized as exceptional circumstances. Here, burglary and poverty are not. As Judge Rovner pointed out, there were 35 days that transpired between the burglary and the hearing. He should have had a backup plan, as Judge Rovner said. Take, for example, us. Both counsels are appearing remotely. We had a backup plan. Petitioner could have done the exact same thing. He had multiple options. He had multiple attorneys, 3 different ones, in fact, that he dealt with in the past. He could have called his current attorney that appeared on the day of the hearing. He could have called the IJ, emailed, or written the IJ, or he could have, like us, appeared remotely. He did none of that. That's a key fact here in the agency's decision. Now, yes, Judge.
I'm sorry to interrupt you, but do you agree with Mr. Yerman's recitation of where we stand at this moment?
Respectfully, no, Your Honor, I do not. So, petitioner did request. Judge Hamilton asked about the 130. To update the court, all parties invoked DHS's assistance regarding a joint motion to reopen pursuant to that I-130. DHS has declined twice to administratively close or terminate or join in a motion to reopen. Now, that does not preclude petitioner from filing the motion on his own accord before the board. A lot of time has transpired. I don't recall exactly, but over a year. At no point has petitioner filed a motion to reopen with the board. In terms of the procedural disposition of this case, I believe Judge Hamilton asked about what if the PFR is denied? How does that impact petitioner's ability to continue his pursuit of relief regarding that 130? It doesn't impact it at all. He still can file the MTR. Those are 2 mutually exclusive issues, such that if the court were to grant the PFR and remanded it back, my position is different than my colleague. That's not correct. The IJ is solely constricted to the issues before us, whether or not burglary and poverty are exceptional circumstances. This is not the vehicle to get it back in front of the judge to consider everything holistically. That's what the motion to reopen is for. And as far as I'm aware of, as of this morning, no motion to reopen has been filed. That sort of dovetails into these alternatives, these, as you said, Judge Rovner, the backup plans, the multiple options that petitioner has. That's yet another option. And as of today's date, he has not taken advantage of that.
And what would happen if, when we leave court today, he does take advantage of that?
It would proceed on its own sui generis track, Judge Rovner. So if the petition for review is denied and the court finds that the agency properly exercises discretion here, what happens is we have a final removal order, but petitioner would file the MTR before the board, and it would
Sorry,
be
the
docketed.
what? Would file the what?
I'm sorry, the petitioner would file the motion to reopen
Okay,
his
we are
proceeding.
not as familiar with these acronyms as you are.
I apologize, Judge. So the petitioner would file the motion to reopen before the Board of Immigration Appeals and ask for consideration to reopen proceedings, terminate the removal order based on his approved I-130 with a request to remand back to the immigration judge for determination as to whether or not he is eligible and would receive adjustment of status. Now, that's a discretionary determination. Just because he's got an approved I-130 doesn't necessarily guarantee that he'll adjust status, aka obtain his green card. That is that's all within the court's all within the board's discretion, and should it be remanded, the immigration judge's subsequent discretion regarding the issue of adjustment of status. So that issue, Judge Hamilton, is completely separate and distinct from the issue before the court. It should not weigh in the court's decision at all. They're two separate issues. Here, we should all be focused, the court should be focused in on whether or not burglary and poverty qualified as exceptional circumstances to excuse his absence in court. And we have jurisprudence in Mena Mendoza and Bauer that guide us, that along with 8 USC 1229 alpha, that says instances like exceptional circumstances have got to be similar to battery. Quote, I'm quoting the statute here: battery, extreme cruelty, serious illness, or death. These circumstances, burglary and poverty, do not equate to that, particularly since this financial situation existed at least 6 months prior to this hearing, and the burglary occurred 35 days prior. My colleague asked us multiple times to step into the shoes of petitioner. Well, we have, and went by creating alternatives, by appearing remotely. And certainly he could have done the same. He had alternatives. Take Nazarova, for instance, Your Honors. My colleague cited that as a seminal case. In that particular case, the exceptional circumstances was the byproduct of government action. The government failed to provide an interpreter. So the petitioner in that particular case immediately exercised an alternative option and went out and hired her own interpreter. And on the day of the hearing, her own interpreter failed to show up. So she was left with two poor choices. Either she show up in court without the interpreter or wait for the interpreter. But when she was late, she immediately contacted the court. Here, we don't have that sense of immediacy. We don't have government action that initiated the circumstance. And we don't have the petitioner exercising any multiple options or taking any initiative to contact his attorney that appeared before the immigration judge, or to contact the immigration court directly. And I think that is a key element here that distinguishes this case from petitioner's seminal case of Nazarova. If the court doesn't have any further questions, the government would like to briefly conclude by saying that the agency properly exercised its discretion in denying the motion because the petitioner failed to show his absence was due to exceptional circumstances. That's the sole issue that this particular case rests on, not any discretionary decisions regarding his I-130 or his I-485 to adjust status. That is completely, that's sui generis and separate than the issues before the court. A denial of the PF4 does not impact petitioner's ability to pursue that relief in any way, shape, or form. In that regard, we'd ask that you deny the petition today. Thank you.
Mr. LaFort, you're quite welcome. Mr. Yerman, you had a little time remaining. You're welcome to use it.
You may be muted.
Thank you, Your Honor. May it please the court. My name is Yerman. I represent the petitioner, Mr. Namag. He is here today. He is unable to attend. 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 He is unable to attend.
Lost a few seconds there. Okay. If the court grants the petitioner's application for relief and instructs the BIA to reopen the case based upon exceptional circumstances, the immigration judge will have full authority to hear whatever relief is available in front of the court at the time. Number one. Number two, yes, a motion to reopen can be filed, but it's based upon sua sponte. And practically speaking, Your Honors, in the 27 years that I've been practicing immigration law, the BIA has never granted a motion to reopen after a final removal order based upon new facts, such as an approved petition by a spouse or a child. They've said clearly that that would allow people to sit around and wait for a petition to get approved. So unfortunately, the motion to reopen is a dead end and is not possible. So if this petition for review is denied, Mr. Namaga will have no relief available, as he will have a final removal order and he will be removed from this country without any waivers possible to return. Thank you.
You're quite welcome, Mr. Uriman. Mr. Lafort, thanks to you as well. We appreciate it. We will take the appeal under advisement.
Thank you.
We'll move to our second argument of the morning, and that comes in appeal number 242219. Planned Parenthood, the Great Northwest, Hawaii, Alaska, Indiana, and Kentucky versus the Commissioner of the Indiana State Department of Health and others. Okay, yeah, I see Ms. Lawrence. Nice to see you. Mr. Rose, nice to see you. Okay, you may begin.
May it please the court. Generally, children are not allowed to make medical decisions by themselves. In the vast majority of cases, minors' parents participate in and must consent to their child's medical procedures. Abortions are not an exception to that rule. To reiterate that basic point, Indiana passed a law which bars knowingly or intentionally aiding or assisting minors in obtaining an abortion without either parental or judicial consent. The law does not regulate speech on its face. It regulates conduct. Even if this court decides that the law picks up some speech as it regulates that conduct, the law should be subject to, at most, intermediate scrutiny, which it easily satisfies. Now, before getting to the constitutional issue, I want to briefly flag for the court that it should assure itself that it still has jurisdiction here. And that's because
before you do, I have a question I'd like to ask you.
Yes,
and it's this. When you speak of parental consent in the briefs, this is my question. Consent to what? Indiana, obviously, has the authority to place conditions on an abortion performed in Indiana. But are you saying that Indiana can impose its own consent requirements on abortions that are to be performed in another state, or that Indiana can require that parental consent for an abortion be given before a minor can even be given information about legal abortion services outside of Indiana? Just so I'm on the same page with you as to parental consent. And then I know you obviously want to get on to standing, but I'd really appreciate this.
Certainly, Your Honor. And I want to be very clear about what Indiana's law actually does, because there seems to be some confusion about that in the briefing. So first of all, Indiana's law says that it has to result in a minor obtaining an abortion. So for example, if a 13-year-old comes in and says, I'm doing a project on abortion law, Planned Parenthood isn't limited in saying different states have different laws about what is required to get an abortion. Of course, that isn't covered under that law. What Indiana's law does do is that it says that in certain circumstances, generally, abortion is banned. In certain circumstances, minors may receive that abortion if they have certain parental consents. So while the parental consents in Indiana do not apply to abortions in Illinois, what it does do is that it says people within Indiana cannot seek to evade those requirements. And another thing I want to be very clear about is what exactly the injunction is limiting the state from enforcing right now. And the injunction limits not only the providing of information, but also referrals and calling another doctor on behalf of a child who is there without any parental consents. The only thing I wanted to flag on the standing issue is just...
Well, are you telling us on that point that you think the injunction would be acceptable if it distinguished between providing information and providing a referral?
We're not saying that the injunction would be acceptable, but that at minimum it should be narrowed to eliminate the providing of referrals, which is...
What's the difference between providing information and providing a referral, a constitutional difference?
Yeah, absolutely, Your Honor. So as the unanimous Eighth Circuit just decided, providing a referral is part of the provision of medical treatment. And so a referral is conduct that can be regulated by the state, and it doesn't fall within the same ambit as providing information generally. Now, of course, one of the things that's important to discuss is that providing information generally is not inherently protected, as the Supreme Court decided in Holder. But rather, as Rumsfeld explained, when a speech regulating conduct, here aiding and abetting a minor in evading these parental consent requirements, manages to pick up some speech, we have to look at whether the content of the speech is what triggers the law or whether the result is what triggers the law. And that's from Rumsfeld, that content-result dichotomy. Here, Planned Parenthood could say, you can go to Illinois and get an abortion. And the result is what's going to trigger whether the law is implicated, not the actual content of the speech. So what I mean by that is, in one instance, you have a child who is sitting there with both of her parents who are holding their ID, her birth certificate, and a notarized consent form, and they say, we want to get our child an abortion, and Planned Parenthood says, you can get an abortion in Illinois. You could also get an abortion in Indiana, depending on the circumstances. That is going to be different than if
but so to answer that question legally, and I suppose then they could refer also, right?
In that instance, they wouldn't be aiding and abetting in evading the requirements because...
But if, for example, the document is not properly notarized, or there's some question about the formalities of the consent, then that would still be a violation, correct?
It would not be, because the law says that as long as the person is attempting to fulfill or in the process of attempting to fulfill, you can't knowing or intentionally aid or abet if they're standing there and saying, we just got to go down to the notary.
If a girl comes in and says, I need this information, I'm going to talk to my mom tonight about getting consent, is she attempting to comply with the requirement?
That might be a closer question of fact as to whether the law actually applies, whether there is knowing and intentional evading of the statute. But once again, that's not what the injunction is limited to. The injunction applies just as much to a 14-year-old who comes in and says, I've got to get an abortion and I need to do it this week before my parents find out. The injunction applies just as much to Planned Parenthood setting up an appointment, referring and calling an out-of-state provider for that child as for someone else. And that's one of the largest issues of the injunction here, is that it doesn't actually limit itself to the circumstances that the district court judge raised. So even if this court were to find that this isn't subject to intermediate scrutiny, or certain elements as applied were to violate the law, were to violate the First Amendment, the injunction has to be narrowed to those instances.
How would you do that?
Well, it would depend, of course, in our view, the entire law is permissible because it satisfies intermediate scrutiny.
I'm asking about your fallback position, which you just proposed.
Yes, Your Honor.
What is it specifically?
If this court were to say that providing information generally falls within the speech is protected by the First Amendment, we would suggest that the allowing Planned Parenthood to provide referrals and to call people on behalf of other persons is not properly within that same First Amendment ambit. That's more specifically speech. And one of the things...
I'm going to stop you. You know, virtually all states require some form of parental or adult involvement in the abortion decision for a minor. So to that extent, how does giving an Indiana minor information about abortion in other states undermine parental consent or the interests of parental consent serves? How does it?
Judge Rimmer, is your question if you gave information to a minor to go to a state where she also would have to receive similar parental consents, that wouldn't undermine the requirements of the law?
Pretty much. I'd love to hear that answer. Yeah.
Yeah. So I think there are two things there. So the first is, if those laws match up with Indiana's law, that might be a closer question of whether Indiana's law applies. But once again, this goes back to the injunction. The injunction isn't limited to Planned Parenthood can provide this information in situations where there's not a close match because the same amount of parental consent is required. And there are some states like Illinois that don't require any parental consent for a child to get an abortion here. And so there also are those states where there is that, where there's certainly a strong interest of the state in ensuring that the parent-child bond isn't broken by a child getting medical procedures without their parents' permission, knowledge, or consent.
Ms. Lawrence, could you direct us to other situations where providing truthful information about the laws of other states is punishable by law?
Well, if Your Honor looks at Holder versus Humanitarian Law Project, in that case, providing information about how to talk to the UN or how to present a case before the UN, I think there's two important reasons to look at that analysis here. Because first of all, like Planned Parenthood's argument that you can find this information online, the law in Holder, you could find information about how to petition the UN online, but you still couldn't provide the direct support by providing it to certain individuals. And then the second way that is applicable here is because providing truthful information is not in and of itself a defense to criminal conduct. So, for example, insider trading almost always depends on someone providing truthful information to someone else. It's how the result of how that information is used.
Yeah, there are certainly a lot of situations where the law protects or prohibits disclosure of information privileges, national security secrets, and so on. But I'm trying to come up with some closer analogy than terrorism here. We think of all the variety of ways in where states differ. We can talk about gambling, we can talk about smoking and vaping, we can talk about divorce requirements, and so on and so forth. And I'm not aware of any of those situations where where truthful information about legal behavior in those states can be punished.
Well, and I want to be clear because the Planned Parenthood talking about what you can legally do in other states is not punishable under this law. This law doesn't regulate that type of speech on its face. The only question is that information...
If a person who receives that information acts on it, correct? That's what you want to punish.
If that information was provided either knowingly or intentionally, there's also a scienter requirement. So generally sharing the information or perhaps sharing it to a teen who isn't pregnant isn't going to trigger the statute because the statute is regulating conduct. Like this court said in KC, that the state is allowed to make a decision about how medical procedures should occur in the state. And
although we gather that parental control is less important in KC than it is here. In the state's view, correct?
To be clear, in KC, the argument has always been that parents should have the right to decide what legal
But the state in KC was telling parents what they may not do for their children, correct?
The state was regulating what medical treatments could be and what medical procedures could be provided within the state. And so too here, the state has regulated what medical procedures may be provided within the state.
Did you want to say something on subject matter jurisdiction? You were, a bit ago, you were about ready to make a comment on that.
Just briefly.
At the very beginning, if I recall correctly, so.
Briefly, Your Honor, we just would like to flag for the court that there are no facts in the record about how Planned Parenthood is currently operating. When this case began, when all the facts were submitted, Planned Parenthood operated abortion clinics within Indiana and had licenses to do so. Now Planned Parenthood no longer operates abortion clinics, and we understand the facts on the ground are changing, such as recent press releases that have talked about closing of clinics or increased telehealth. We just don't know how they currently are operating in Indiana, and it may be worth investigating that before this court can assure itself of its jurisdiction. If I may, I'd like to reserve my time.
Okay, very well. Mr. Rose, good morning.
Thank you, and may it please the court. The aid or assist statute prohibits Planned Parenthood or anyone else from providing factually accurate information about lawful out-of-state abortion services to willing listeners, and in fact the district court explicitly limited its injunction to information about lawful services. That restriction does not become constitutional simply because those listeners are minors, particularly because, and I do want to stress this because I think it is lost in a lot of the state's argument, this statute applies even if the minor's parents are sitting next to them at the time. The question in this case that I think is worth asking more than any other is this: what exactly is left of the state's argument if we assume that Bigelow was correctly decided? That case obviously concerned an encouragement statute applied to the provision of factually accurate information about lawful out-of-state abortion services. We have spent a lot of time arguing about speech versus conduct, speech integral to criminal conduct, the meaning of Casey, and so forth, but it seems to me that as soon as you accept Bigelow as a given, the state is left with two things and only two things: standing and the application of strict scrutiny.
Can we talk about standing for a minute? I think you can help us out here. Is your client suing on behalf of itself in an organizational capacity, or is it suing on behalf of members in an associational capacity? And the reason I ask that question is because it seems to me that there's only two ways that it can sue. It's either suing on behalf of itself or it's suing on behalf of members, under like the Hunt line of cases.
Of course, Judge, and I'm not entirely sure what you mean by members. Planned Parenthood is suing as an organization with employees who provide this information, the physicians. I don't think Planned Parenthood...
Okay, is it suing on behalf of itself as an entity, as an organization, separate and apart from its employees?
I don't even know what it looks like to view those as distinct, and I apologize, Judge, I'm not trying to be coy. Planned Parenthood's physicians and other healthcare staff are providing this information as a part of their duties for Planned Parenthood. So whether we view that as organizational speech or as Planned Parenthood suing on behalf of its employees and agents.
In paragraph 11 of the complaint, and I know this is going back a ways, okay, and I'm not meaning to pop quiz you, okay? The organization says that, and I'm quoting from paragraph 11, it brings this action on its own behalf, on behalf of its patients, on behalf of its staff, including physicians, as employees or contractors perform abortions, etc. The reason I want to focus at the outset on whether it's suing on its own behalf as an organization is because the passage of time complicates that. And all I mean by that is, as you acknowledge in your brief, in that footnote 3, that one of the named defendants, the Commissioner of Health, is really not a proper defendant for purposes of the injunctive relief because of the changes in Indiana law with respect to licensing. Okay. So for all practical purposes, that means that the only proper defendant for injunctive relief is the Indiana Medical Licensing Board, right?
Yes, Your Honor.
Okay. And if Planned Parenthood is suing, we'll come to the on behalf of the employees, and don't worry, I'm going to give you time. Okay. If Planned Parenthood is suing on its own behalf and it's suing the Indiana Medical Licensing Board, that gets odd from a standing standpoint. And the only reason it's odd is because Planned Parenthood doesn't hold a medical license. Doctors do. Right?
Of course, Judge, although that relationship is so close, I can't imagine.
Okay, and the licensing board can't seek monetary relief against Planned Parenthood, and nor can there be civil penalties sought. Civil penalties can only be sought, by parents or the minor or the guardians or something. So it's odd for me to see how Planned Parenthood itself is a proper plaintiff, given the passage of time and those complexities. So it seems you have to be suing, your client has to be suing in some kind of associational capacity on behalf of its employees. So that would seem to implicate the associational standing doctrine. I don't know, and we know so little about the plaintiff. Is it an association of members?
And Judge, the reason I'm having such a difficult line with this questioning is that Hunt and his progeny, generally, those are membership organizations. We're not talking about employees as members. I think quite clearly, if Planned Parenthood's physicians lost their licensure or refused to speak on behalf of Planned Parenthood because they were at risk of losing their licensure, I think quite clearly that is an injury to the organization itself. So I don't...
like kind of a la Havens Realty, or what do you have in mind?
Judge Havens, to the extent that it still exists, is different in kind. I think that when Planned Parenthood has to tell its employees, you cannot speak, you cannot deliver our message.
Right, but then you have to focus on the only viable defendant that's left.
Of course, Judge. And I think that Planned Parenthood suffers an injury if its doctors cannot speak, or if its doctors suffer licensure consequences, cannot provide services on behalf of Planned Parenthood. This is not an organizational associational standing case in the traditional sense of the term. And I know of no case law out there that says an employer doesn't suffer injuries when its employees cannot deliver its own message.
Well, I mean, all right. I mean, I still think you got an issue with what defendant remains and what that defendant can do.
Sure, and obviously we recognize that the only thing that the Medical Licensing Board can do is against the doctors directly. I just think that is injury to Planned Parenthood itself, whether viewed as an organization, whether viewed as an organization that wants its employees to deliver this message, or whether viewed as simply suing on behalf of its employees. I apologize, I simply don't see the distinction that you appear to see. I do, however, want to turn to the...
May I just say something? This seems that the state defendants would argue in the reply brief that further development of the record is required to confirm standing. I myself am not convinced that the record is unclear as to any material point, but to the extent it might possibly be, wouldn't the fault be attributed to the defendant's failure to contest standing below?
I think, Judge, it's not just the failure to contest standing. I think it's the failure to contest undisputed facts in the record. And I was about to turn to what I think is the second prong of Judge Scudder's question, which is, we obviously recognize that this case was being litigated in parallel to the state court litigation. In recognition of the fact that the state court injunction might not be a forever thing, we made abundantly clear on summary judgment that were the state court injunction vacated, not only would Planned Parenthood continue to provide this information, but its need to do so would increase substantially given that the universe of persons who can receive Indiana abortions has just decreased substantially. That is an undisputed fact on the summary judgment record. If the state had wanted to test that fact, the time to do so was on summary judgment. If it had wanted to put Planned Parenthood to the fire, or force Planned Parenthood to demonstrate that after the state court injunction was lifted, it had fully a year, almost a year, excuse me, between the lifting of the state court injunction and the entry of summary judgment in this case, during which it could have asked to supplement the record. It could have asked to reopen discovery. It accepted standing throughout the court below. It accepted that this is information that Planned Parenthood's physicians actually provide. Obviously, we've argued that it doesn't matter if other healthcare staff provide it. And it did so explicitly. And we understand that standing is non-waivable, jurisdiction is non-waivable, but that's more than a legal argument. That's a factual concession about what's actually happening. And it's a factual concession that we
nobody seems to have focused on standing. I have a hard time understanding that given the passage of time, given the changes in Indiana law, given that the injunction really can't run against the commissioner anymore.
And certainly, Judge, I agree that parties could have done a better job of at least cleaning up the extraneous parties after the state court injunction was lifted. But again, we made clear on the summary judgment record that this is information that Planned Parenthood is going to continue to provide even if the state court injunction was lifted. The time to contest that was on summary judgment. If the state was not satisfied with it, the time to do so was in the district court. This comes very, very late in the day, given that everyone has accepted for 8 years that this is information that Planned Parenthood's physicians provide. The merits. I'm sorry, Judge Rovner, did I hear you? I'm so sorry. The only thing I want to address on the merits, cognizant of my dwindling clock, is the state's attempted distinction between the first prong of the district court's injunction, the provision of information, and the second prong, the referrals or the helping young persons through the process.
Sir, those microphones are recording you, they are not amplifying you.
I apologize, Judge. I want to address the state's distinction between the two separate prongs of the district court's injunction. Quite clearly, under NIFLA, the first prong is subject to strict scrutiny.
Say it again, under...
The first prong, that you cannot provide factually accurate information, is subject to strict scrutiny. It is a content-based restriction on speech. We think it's a viewpoint-based restriction.
I think you were
on
citing
speech.
a case by an acronym that none of us are familiar
You said something
with.
under
I'm sorry.
N?
NIFLA, National Institute of Family and Life Advocates v. Becerra, the Supreme Court's professional speech, or lack thereof, case. The second prong, at its very best, the state's argument means that the second prong of the district court's injunction is subject to intermediate scrutiny rather than strict scrutiny. We think it fails any level, so I think that may be an academic issue. But when we talk about referrals, which is the line the state is attempting to draw, I have a very difficult time talking about that in the abstract. I can't imagine that there is a constitutional difference between Planned Parenthood saying, here's this information in the event you find it useful, and Planned Parenthood saying, here's this information, if you decide to use it, I happen to know that Dr. Smith has a short wait period, is very good with patients, whatever. I can't believe that there is a constitutional distinction between those. The Eighth Circuit in the Brandt case addressed the issue in the context of an exceedingly narrow referral-only statute with a specifically defined manners in which referral was addressed. I think that case could have been resolved similar to KC, as this applies to in-state providers as well. It's integral in criminal conduct. But I don't think that this court is in a position to craft onto Indiana's aid and assist statute some sort of referral exception. If the Indiana General Assembly wants to go back to the drawing board and craft a narrower statute addressed to that particular issue, we can certainly talk about it then. But having drafted the broadest statute imaginable, as I say, I have a very difficult time talking about referral in the abstract. And I think the state is left with the statute that it has drafted. If there are no further questions, thank you very much.
I have a couple. Do you mind? I got a couple. And don't worry about the clock, okay? My question. You seem. I don't want to put words in your mouth. You can tell me. Do you read KC as a facial overbreadth case? And if so, how do you read it that way?
I do, Judge.
What are you looking at in the case to see? And the reason I don't mean to be pointed about it. It just the court talks about it in as applied terms. So that argument throws me off a little bit.
And with respect to the panel in that case, the decision throws me off a little bit too. I think given the court's focus on the fact that this information is being prohibited for in-state referrals, its focus on you cannot provide this information, or the statute includes the provision of this information to persons who cannot legally perform the service, I think the only way to read the court's decision is through an overbreadth analysis, saying that because it has not been limited to places who can legally perform these services, the statute fails under overbreadth analysis. There's a way.
I thought it was the injunction that failed under overbreadth analysis. So.
An injunction that failed, and quite frankly, there is a way to read KC consistent with Bigelow. And the state's reading does not do that. If we read KC to say that you do not have a First Amendment right to refer persons to services, to provide information about services, where those services can be legally provided, then Bigelow was wrongfully decided, and by definition.
Do you read KC at a minimum to control on whether the law targets speech or conduct?
I don't, Judge. I think that the focus of the court's decision was not on conduct, but was on speech integral to criminal conduct. That is still speech, similar to how it's been used by the Supreme Court. Simply telling someone, here's this information about your lawful out-of-state options, that is speech by anyone's definition. If it wasn't, then what I call NIFLA was wrongly decided, because what the Supreme Court was talking about in that case was a requirement, granted compelled speech, not a speech prohibition, but compelled speech saying that you must provide patients with information about their lawful alternatives. We know from that case that when Planned Parenthood does so, that is speech.
Okay, any further points you want to make?
Nothing further from me, Judge. Thank you very much.
Okay, you're quite welcome, Mr. Rose. Okay. Ms. Lawrence, you a minute and a half or a little more left.
Thank you, Your Honor. May it please the court, briefly on standing to begin with, a couple things here. So first of all, Planned Parenthood is saying that there are undisputed facts that existed in the record. All of these undisputed facts were undisputed at the time that Planned Parenthood was still providing abortions in Indiana. And these facts that were in the record about how Planned Parenthood operated all occurred, briefing was occurring while Planned Parenthood was still performing abortions in Indiana. All we want to do is flag for the court is that there are factual questions about how Planned Parenthood is operating now. Now, going on to the merits issue,
Can I pause you just for a second on that? How do you think they're suing? Do you think they're suing in an organizational capacity? Mr. Rose was saying, I don't want to put words in, there's an injury to Planned Parenthood because the statutory restriction really restricts something, at the core of the services it provides, et cetera. So if the physicians are at risk of losing a license, that's an injury to Planned Parenthood because it's kind of acting through its physicians.
And
Are they suing in that capacity, or are they suing as on in an associational capacity?
And frankly, Your Honor, I don't know, and that's part of the issue here is that we don't know. We don't know how Planned Parenthood is operating. We don't know how their doctors are operating. We don't know how their clinics are operating. We just don't know because.
But why? But you all. But why? Why is it take? I mean, this case is the statute's been
Yeah.
around a while. The case has been around a while. There's a ton of history here, and it's now September of 2025, and we're just now having this dialogue.
Yes, Your Honor, that's correct, because at every stage in litigation, we want to make sure that the court has jurisdiction over the case here.
Do you agree with Mr. Rose that there was about a year between the end of the state court injunction and the federal district court, much narrower injunction here?
There was a period of time when briefing had been completed, and so that there was
Nobody
some
raised
time
any
there.
new issues at that
No
time?
one raised those issues at that time, but of course, as Mr. Rose said, that cannot be waived because it's jurisdictional.
This is very belated, and it's, for the first time on appeal, you're challenging their standing to challenge the statute. Just
And if I may, Your Honor, we understand, but part of that is because the facts on the ground have changed. When this lawsuit began, it was challenging multiple different parts of the law. It also, Roe v. Wade was still the law of the land, and Indiana's current abortion laws weren't in place. There has been significant factual and legal change since this case was originally filed, and even as this case was briefed.
If we were to give the district court and the parties a further opportunity to develop the record on standing, do you think it would be appropriate for us to leave Judge Barker's injunction in place pending the resolution of that process?
No, Your Honor, because as we've explained, we think that the judge improperly applied the intermediate scrutiny standard that should have been applied, instead applying strict scrutiny. And
You mean vice versa?
I'm sorry, yes, the judge applied strict scrutiny instead of intermediate scrutiny, but even under that strict scrutiny standard, the reasoning she used to say that the law did not satisfy strict scrutiny were not justifications to show that it wasn't narrowly tailored or in support of a compelling governmental interest. Thank you.
So the late standing challenge is an effort to get the injunction vacated at least for a while.
I mean, the court always has to assure itself that it has jurisdiction, and so whether a court
A principle we're all very familiar with, right?
Yes, Your Honor.
We got talking about standing. I think you had a merits. I just want to make sure you both feel like you've had time to make your points. Do you have any final point you want to make, or if not, we can call it an argument.
If I may, Your Honor, I'd like to just touch briefly on the merits. And one of the things I want to make sure is clear is that the level of scrutiny that applies has to be tied to the law itself. So in O'Brien, the question wasn't what level of scrutiny applies to the very specific action that O'Brien was taking in that case. It was what level of scrutiny applies to the law. So the law here regulates conduct, and just because there's a speech element combined in that conduct doesn't mean that strict scrutiny automatically applies. Thank you, Your Honors.
Ms. Lawrence, thanks to you, Mr. Rose. Appreciate it very much. We'll take the appeal under advisement, and the court will now We'll proceed to our third argument of this morning, and it comes in Appeal 25-1361. Svoboda versus Amazon. Ms. Schuster, nice to see you.
Good morning. May it please the court, I'm Stephanie Schuster here on behalf of Amazon. The district court certified an enormous class of Amazon customers with sizable claims that all require individualized inquiries to determine both liability and damages. This class fails Rule 23's superiority and predominance requirements in three related and reinforcing ways. First, superiority is lacking because the stakes are high on both sides of the V. The average class member has a claim for $60,000, and tens of thousands of class members have claims worth more than $100,000, all plus attorney's fees and costs. These large claims, plus low barriers to suit, give class members strong incentive and interest in litigating meritorious claims individually.
Are there individual cases parallel to this one pending against Amazon?
There are other BIPA cases pending against Amazon, but not about this particular technology. No.
Brought individually challenging the VTO, what is it, virtual try-on?
Virtual try-on, Your Honor. No, this is the only one. This one's been pending for some time.
Thank you.
At the same time, aggregating these already large claims creates an unnecessary risk of an unconstitutionally excessive damages award for Amazon.
Well, given the damages under BIFA are discretionary, and thus amounts less than the $1,000 and $5,000 awards that are authorized by the statute or permissible, why should we assume that excessive damages that you hypothesize are realistically possible? Do you really think a class member is going to walk away with $1 million in this case, or $60,000 in this case?
That's a good question, Your Honor. That is precisely what the plaintiff's theory of liability is, that these individual class members would walk away with $5,000 per use of the VTO feature, $60,000. Again, for hundreds of plaintiffs, it is more than $1 million, and those are the damages that they're seeking. And we have to assess whether class action is appropriate based on the claim that the plaintiff has brought and style.
Could you address the point made in Murray to the effect that we should not worry at the class certification stage, at least not deny class certification based on the possibility that an unconstitutional award might eventually be imposed? The time to deal with that is at the back end.
Two responses to that, Your Honor. Murray was materially distinguishable. Murray dealt with small potential recovery of $100 to $1,000 max per class member, unlike the large sums at issue here.
The principle was stated pretty generally, though, and seems to me, at least as a judge, to make a lot of sense in the way we administer cases.
Well, I think you need to read Murray, though, Your Honor, in context of the small value of the claims was important, because the practical alternative to class litigation with those small, low-value claims was no litigation at all. That's not the case here. There's every incentive here for individual class members to bring their claims.
And yet none have.
Correct, none have. There is a class action pending, but that is not a reason to determine that class members don't actually have an interest, again, with claims worth over $1 million, $500,000, $100,000, that they don't have every interest in pursuing those claims on their own without the class pending. But Murray the holding was made in the context of, we're not going to say no class action because of a potential excessive damages award, because doing so now rather than on the back end means that these claims don't get litigated. That isn't a concern here precisely because of the high damages awards in this case. Murray also didn't involve the other problems with class certification that we have in our case, which on top of the high damages award is predominance issues that affect both liability and damages. As to liability, each class member will have to prove for each and every use of the VTO feature that they were located in Illinois at the time. That can't be done on a class-wide basis. It requires an individualized inquiry. Plaintiffs kind of gesture towards Amazon's data, and so did the district court, but that data is not reliable for that purpose. We put in an unchallenged
on this point, Ms. Schuster, can you be as specific as possible?
Sure.
With respect to what's in the record about why it is that the IP address, and I think it gets overlaid with what you all call geolocational information.
Sure. The geolocational information is just a way of estimating based on an IP address
Right.
where the user is actually located, because IP addresses themselves generally correlate to geography, but not state lines. They're
Okay,
also
so what
imprecise.
is it about the IP information and the geolocational information when you combine that with, as the district court did, the billing address information and the information that will come in time on a claims form or claims affidavit? Why is it that gives your client, pause on the predominance, on the B3 predominance question?
Certainly, Your Honor. So the billing addresses don't tell you anything, right? They tell you where the primary billing address is associated with the user's account. That is not always associated with the user's residence, as was the case with one of the plaintiffs here. But on the IP addresses in particular, what our expert report showed, our unchallenged expert report showed, is that these are at most, in guessing sort of which state the plaintiff is located, these are at most a guess that are 74% accurate of determining whether a user is within 100 kilometers of a given city. So for example, if Amazon's guess for geolocation based on IP address is Chicago, there's a 74% chance the user was in Chicago, Gary, Indiana, Kenosha, Wisconsin, or anywhere else within a 100 kilometer
So
radius of Chicago.
is this Christopher Stengel? Is that
Correct,
who you're
Your Honor.
talking about?
That's correct, Your Honor.
Okay.
And if a claim form for somebody with an address in Chicago says, and I've never been to Indiana or Wisconsin, does that give us a little more confidence?
No, because that relies on the individual's say-so, and as I've alluded to at the beginning, they have
We call that evidence, right?
well, evidence that the defendant has a right to challenge, and that's
Yes.
precisely our point. So to challenge that evidence, the practical way to do that, to challenge that evidence, will require tens of thousands of individual hearings, at the
You
very
wanna do
least,
that?
to do cross-examination.
You want to do that? Has
but
anybody
it's-
said you cannot?
Well, that's our point, though, Your Honor. To do that is an individualized inquiry. There are over 160,000 members of this class. We would need to do that with every single class member. And that is why we're saying that there is a predominance problem that would make a class action improper and inappropriate here. because
You
we
may have a
160,000 hearings.
constitutional right to do that.
We agree that we do, Your Honor. We certainly do. We
Okay.
agree that that's why the class
And
action
that's
can't
always
proceed.
going to be true in large class actions, right?
That's right, Your Honor, yes.
And we count on common sense and economics to keep all that within control. But nobody is going to prohibit you from taking those depositions if you want to, right?
If we're going to be allowed to do so, as again, we have a constitutional right to do so, the result is class litigation that predominates. And this isn't the type of case where common sense and economics lends itself to using sort of a sampling of data. These are class member affidavits that would be filled out based on an individual's recollection about an online shopping experience on their phone from years earlier. There isn't a statistical way, and no one has proposed one, neither the district court nor the plaintiffs has proposed one, that provides a reliable statistical methodology from which you could do data sampling. We're talking about people's memories of events from long ago, and we, like you said, Your Honor, have a right to test that through discovery and through cross-examination. And our point isn't that we're being deprived of the right to do that. It's that since we must have that right, individualized issues will predominate because there will be tens of thousands of mini trials showing that class action is inappropriate here. And it's unnecessary, given the high individual damages plus the strong incentives to sue.
So you'd rather have tens of thousands of individual cases. You know that's not going to happen either.
It may, Your Honor, because what we have
How
here...
how could that possibly happen?
Well,
The available statutory damages aren't sufficient to make it feasible for a consumer, to pursue relief in an individual action. And once you appreciate the fact that the statutory damages are discretionary, both in the granting or denial and the amount awarded, that, the specified statutory amounts serve as a cap.
Your Honor, and so here's what we have here. We have statutory damages that, again, are high, and they are on their own significant in many instances to provide sufficient incentive on their own to sue. But the Illinois General Assembly was clearly attuned to the problem of negative value suits, and it crafted BIPA to provide plaintiffs with strong incentives to bring meritorious claims on their own if they chose to do so. It provided a right of action absent any actual injury. It provided a statutory damages remedy, and it gave prevailing plaintiffs a right to recover their attorney's fees and all of their litigation costs. That is precisely the sort of incentives that show that a class action is not necessary. The Assembly set this up so that individual claimants could bring meritorious claims if they wanted to. The fact that they haven't may be, and we submit, is more plausibly indicative that individuals do not think that these claims are that meritorious or that strong, but that's not a reason to aggregate weak claims to potentially ruinous liability in a class action. It's a reason to allow individuals to bring these claims and control them if they want to, particularly because on plaintiff's theory, they are so worthy and worthwhile. And to the point about discretionary, sorry, Your Honor.
Go ahead.
To the point about discretionary damages, we agree, Judge Rovner, the damages are discretionary, but plaintiffs in the district court have ignored this fact and insist that damages can be assessed based on a simple formula, multiplying $5,000 times the number of VTO uses in Illinois. That's impossible to square with the Illinois Supreme Court's holding that these damages are discretionary rather than mandatory. The word discretionary has to mean something, and it can't mean a static formula. If it did, that's the opposite of discretion. And discretion can't mean, as plaintiffs in the district court have suggested, that courts simply have the power after the fact to reduce an unconstitutionally excessive damages award. That is a constitutional requirement. It is not an exercise of discretion. Discretion requires, it's not an unfamiliar concept in the law, it requires wide latitude to act within the bounds of reason and consider all of the circumstances relevant in a particular case to an award of damages.
Would you envision I want to go back to the location information thing. If the case remained certified and it proceeded forward, and envision that you're at a trial, would one of your client's arguments, I'm not asking you to reveal confidences or anything, it just seems to me from this expert report, one of your arguments would be the plaintiffs fail in their effort to use the IP addresses and the geolocational information to prove a central element of their claim, that this occurred within the state of Indiana. And it's, in looking at the Stengel expert report, I think the way, at least I understand the way this case has been teed up and alleged and all that, is that a lot of the use of the VTO app or software is mobile.
All of it.
All of it? Okay. Okay. So would a lot of it then be, do you believe a lot of it would be using the app via a cellular data connection as opposed to a broadband data connection, unless you were doing it in your home?
That's correct, Your Honor.
Okay, and the reliability of the locational information goes down significantly, at least according to Stengel's report.
Correct.
If you're dealing with cellular information, it
Yep.
goes down to about 50% or 55%.
Yep, 54% within a 100-kilometer radius on the cellular alone.
Okay, and would that be? Do you anticipate that would be one of the defenses that you would offer at trial? That they bear the burden. We don't bear the burden of coming forward with locational information for them. They're trying to use our locational information. They haven't proven an element of their claim.
Sure. In the world where that's the only evidence that they have of location, that's
Well,
not
they're going to combine it with the billing, and then later a claims form.
the claims form, or in the case of the named plaintiff's deposition testimony. But again, our point is that we need to be able to challenge that deposition testimony. If it were just the data, if they said we're going to rely on the data, one fell swoop, this would be a different case. But that they can't do that because the named plaintiffs themselves aren't relying on the data because they don't appear in it. I see that.
Don't you have account billing information, IP address, geolocation data, class member affidavits, discovery? Gosh, I don't know.
We have account billing addresses, which don't tell us anything about location, and then the IP addresses, which tell us, again, have high error rates and often are a little better than a coin flip, Your Honor. We don't have discovery from the individual class members about their individual circumstances, and to do so is precisely our point. That is the predominance problem. I see I have just a minute remaining.
Could you compare the geographic issues here as they affect liability to the proof of purchase issues in Mullins against Direct Digital and other similar consumer class actions?
Certainly, Your Honor. A couple of points like that. So Mullins was looking at proof of purchase for, I think it was a joint pain supplement, looking at individuals to identify themselves, again, just for purposes of class membership at the threshold that they purchased
Well,
this
it's
product.
obviously an essential element of liability as well, that they made the
Absolutely.
purchase.
An essential element of liability as well. The issue there, again, not superiority, but ascertainability and class membership. And what the court found is that we can have this and we can sort it out later. Now, I would submit to the court that there's something materially different between testing based on potentially, to Your Honor's earlier point, with statistical evidence about whether these individuals actually purchased the product using potentially a representative sample size of, were these the number of products they said that they purchased consistent with what we have about sales data. There are other ways that the court envisioned, although the Mullins court didn't get into any specificity, the Mullins just said we leave it for another day, but there do have to be means to test the veracity of these affidavits. What we have here is more than just an I purchased this product. It's I used it while I was in this location and I remember that for these reasons, and that's something we need to be able to test. And again, the stakes are much higher here than they were in Mullins. In Mullins, you were talking about $70 per claim, and here we're talking about an average of $60,000 per claim, and in many cases, much, much, much more. So,
Could I ask you briefly to address the Rules Enabling Act problem that you were raising? What do you think that is?
It's the flip side to the same issue. So if we're not able, if the class is structured in such a way that Amazon is not able to test the veracity of claim form affidavits and conduct these tens of thousands of individualized proceedings, and is not able to raise individualized defenses based on how discretion should be exercised for damages, then you have a Rules Enabling Act problem, because it abridges our ability to assert individual
If the judge says no, you may not do that.
Correct. Then we have a problem.
Do we have any indication the judge would prohibit you from doing that?
Well, the judge is saying that this can be, the judge seems to have assumed, Judge Alonso seems to have assumed that using billing addresses, IP addresses, and claims form affidavits will make this a mechanical process.
Where do you get that? I don't get any indication there that he intends to prohibit you from challenging or putting on any evidence you think is relevant.
Correct. Again, it's our alternative. We will credit and we will presume that the judge intends to allow it, but that is the
That
predominant
seems to me
problem.
what we ought to do too, rather than deny class or overrule class certification on the theory that something terrible might happen.
But again, that's the alternative if you're not going to allow it. But if you are going to allow it, you walk right into the predominance problem. You can't avoid those tens of thousands of individualized inquiries. It's either you have a predominance problem or you have a Rules Enabling Act problem. Either way, class certification isn't appropriate here.
But don't you, we're going to give you time on rebuttal, all right? Don't worry about the
Thank you,
clock. All right. To Judge Hamilton's point, don't you read the district court opinion as offering you precisely that opportunity? I mean, by its terms. In other words, I don't want to put words in your mouth, but I don't know where the fear or the worry about not having that opportunity is coming from. I mean, the district court judge expressly addressed that. So I don't know why he would address it and then somehow forget it later.
Certainly, Your Honor, and he addressed it by saying, yes, of course, Amazon's going to have an opportunity to test this evidence. What he didn't do is look up the implications of doing that. So our point is this. You either have this predominance problem, which he ignored, or you have a Rules Enabling Act problem. If you're going to comply with the Rules Enabling Act and give us the ability to test these claims consistent with due process, then you have, again, at least 160,000 mini trials that
Or you
create the
say,
predominance issue.
as a practical matter, I know Amazon is bluffing about this because there's no way they're actually going to try to do this.
I don't think that would be
But we
an
will give
appropriate
them
exercise.
we'll give them the opportunity as long as they want to.
I don't think that would be an appropriate exercise of discretion for the district court to
No,
surmise that
what the
Amazon
district
is
court
bluffing.
does is say, go ahead.
Correct. And again, that's where the predominance problem lies. Rule 23B requires that individual issues not predominate. Common issues must predominate. If individualized issues do, then class certification is inappropriate under Rule 23, whether you think that the defendant may or may not do it. We will do it. I will tell you that. We will test these affidavits because this is our right to defend our claims. And doing that, again, we're talking about mini trials for each individual class member about each use of the VTO feature. So not just one use.
Yeah, I'm not, from what you're saying, it's not clear to me that you're going to have to get to the affidavit point if what has been represented about the unreliability of cellular-based mobile connections using the VTO app. I mean, that's the point you're making. If it's 50% reliable, why do you have to get into the whole affidavit at that point? They haven't proven their claim.
We agree, Your Honor, and on the merits, one of the arguments that we would make is that they haven't proven it. But let me use the name plaintiffs as an example. They again don't appear in our data, so you can put the data aside. They don't, according to our data, they've never used the VTO feature from Illinois once. Neither of the two of them. What they have is deposition testimony saying, well, that can't be right. I did use it. I used it many times. Okay, that's the case that these individual plaintiffs are going to put on, and that is even with that argument and those challenges to the reliability data, which is the argument that we're making. That's going to be the case for every individual class member. The only difference is we've been able to conduct extensive discovery of the named plaintiffs. We haven't had that opportunity with the others, and to do that creates the predominance issue.
Okay, we'll give you a couple minutes on rebuttal.
Thank you, Your Honor.
You're welcome. Mr. Keogh? Yep, good morning.
May it please the court. First, before we get into what counsel just said, I want to address a threshold issue. Nowhere in Amazon's opening brief, reply brief, or even really today, did they ever once state the trial court abused its discretion. They don't argue once there's a legal error or clearly erroneous factual finding. The only time you find that phrase, abuse of discretion, is when they cite the standard. And even then, they don't say the trial court abused it. So did the trial court make a factual error? Clearly erroneous factual error? Did they make a legal error? Clearly, Amazon disagrees. But it's their burden to show abuse of discretion, and they never even articulated it, let alone argued it. We think that's fatal to this appeal, and that should be the end of it, for failure to carry the burden. And the reason why we submit they didn't argue that is because this case and the trial court's use of discretion is in line with every other appellate and trial court's decision. Every court who's looked at BIPA has recognized the focus is on defendant's conduct. Damages focuses on defendant's conduct. There's no individual issues. And the courts go out of their way to say that this law is almost demands certification. You don't even have an outlier here. I mean, I don't recall a single consumer law that doesn't have a minority opinion of judges going the other way, especially on certification. So, I'm not saying the court rubber stamped anything, so please don't get me wrong. The trial court took pleadings, took additional authority, had oral argument, which is somewhat rare in this building, and then wrote a lengthy opinion.
So, Mr. Keogh, let's assume there's either a settlement or you prevail at trial on the merits on behalf of some named class members. What does the claim process look like from your point of view?
Well, that's the thing here is usually when we have either a settlement or trial, you get together with the defendant and you work out these things. You have, it's one of those things where...
I understand. I'm asking you, what is in substance? What does it look like?
Well, I can envision even a two-tiered. One, because remember, the court found the majority of the class, their billing address and delivery address matches the IP address. So maybe for that portion, they don't even need an affidavit. And maybe Amazon's going to insist on it. So we'll probably say, okay, fine. And the affidavit is an accommodation to Amazon. Well,
it's not an accommodation. They're entitled to insist on it, right?
Well, I'm not sure, Your Honor, because if the information data we have is sufficient, it might not be needed. But to the extent they want it, we talked about the Rules Enabling Act, but they waived that. They never brought that up before the trial court. And we brought that up in our appeal, and they basically acknowledged that reply.
All of this, we're trying to look way ahead, right? We're at early stages of this case. So they have their due process rights. They have the right to challenge claims, right?
Yes.
Everybody in the room, I think, understands the economic and practical pressures, but in terms of formal rights, would you agree, for example, that Amazon has a right to depose a class member?
I would think on a sample basis, yes. Everyone, the Beaton case that this court has says, fraud's not an issue, that the trial court has plenty of tools in class administration working with the class administrator. So that kind of ties into your earlier question where you can have a process where you can ask a series of questions. You can have a process where the class administrator cross-checks the information submitted on the affidavit with the delivery, billing, IP, geolocator. Mm-hmm. Really what they're saying is they want a video of Jeff Bezos and the class member next to him taking the shot. I mean, there's very few cases where we have this much data. And I want to make it one point.
I understand, but let's go back to my question. Do you agree they have a right to take a class, an absent class member's deposition if they want to, if that person is asserting a claim?
I would generally agree. I don't agree there's a right to depose every single class member, Your Honor. I think the case has said that you can use other mechanisms. Mullins talks about that too for sample data. And, I mean, so that would be our first position. I wouldn't say as our fallback, if that's what the court rules, we would do that. Here there's a class of a couple 100,000. It's not a large class as far as that goes. So if they wanted to depose everyone, and that's, we would do that. We wouldn't say we're not going to do that if the court awarded it. But there's other procedures before you get there.
I understand there may be a lot of other practical alternatives. I'm talking about formalities, formal rights, if people want to insist on them.
I don't think the rule, Negligence Act, and mind you, we did not brief this at the trial court, requires a deposition of every single class member. And to the extent it does, we'd be set to do that. So I don't think that's an obstacle, and I don't think I'm being clear as I don't want to state my position as something that is a barrier to certification here. If the trial court held that that's the issue, then we would do that. Sorry, Your Honor.
Excuse me, please. Let's say they decide they want all 160,000 deposed. Are you ready for that?
Your Honor, if that's what we had to do, we'd have to do that. I mean, luckily we have Zoom now, so we can do it in a way that would make it, efficient, hopefully. But we would prepare to, do whatever it takes to proceed the class. So,
Mr. Keel, can I ask you a question about that geolocational?
Yes, Your Honor.
Okay. So it seems like you all both agree that the statute has to operate in the state, so it doesn't have extraterritorial effect or anything. So one of the elements of the claim is that that VTO app, or however we're calling it, was used within the state. And it seems to me that you all are relying upon a combination, and the combination is important here, of three sources of information to prove that element class-wide, if you will. One is the IP address combined with the geolocational information. Two is the billing address, and three is the claims form or affidavit, whatever you want to call that. And it's the combination of those three that, as I understand your position, you say, that gets us there on that element, by a preponderance. Do I understand that correctly?
Yes, I would also add there's a delivery address too. So you're not just looking at, a delivery address. That's also an important factor too.
What do you mean delivery address? Like what does that
Where
mean?
the product was delivered. Was the product delivered?
Like if you
Illinois,
ordered
billing,
lipstick or something, where it went?
Yeah. Because sometimes that might differ. And one thing I want to point out here, and we put it out in our brief, but the expert report, they talk about that 74% of the data is accurate to the city.
Right.
And Motiface was 85% to the city, I think, or county. But that is Amazon-wide. That is not our class. They never had their expert look at, here's your 100-something thousand people. What is it here?
So part of what has gotten my attention here is, they're not under a legal obligation under BIPA or anything else to maintain IP and locational information for you all, right? They have it. You've sought it in discovery, and there's no question it helps you to some extent in proving your claim, if it proves reliable to a certain degree that way. But what I wondered about is, was there enough grappling in the district court with the reliability or lack thereof of the geolocational information? Because what kept running through my mind is, how are you going to prove that element, class-wide? You're attempting to do it on the basis of common evidence. Can you do it? Or is it more that, well, we're going to kind of get close enough, because there is some reliability in it, meaningful. And then when we get close enough, my words, not yours or anybody else's, the burden kind of shifts over to Amazon, and they can come in and disprove it. And I'm just wondering if that's the way the litigation were to proceed, have you proven the element of your claim?
Well, at certification, no. We've shown that we can prove it. I think that there's a distinction there, and I'm not trying to be cute.
Yeah, will those three things though, and plus the delivery location, will they combine in your view to prove that?
Yes, because if you look at, one of the points in your question you made is whether the court grappled with it.
Yeah.
And the court explicitly found that for the majority of the class, that the billing address and IP address matched, and it was talking about reliability. So the trial court didn't ignore anything. It walked through the data. It walked through the data points they had, and it found that for the majority of the class, they're more reliable. So, let's take a step back here. IP addresses are used every day, or actually every day, often in this building criminal proceedings to show where a defendant was located, to show that some criminal activity took place in between, state lines, across state lines. And that's to show whether they were beyond a reasonable doubt. Here, we need to show by preponderance of evidence, obviously, in our civil case. So the only evidence they have is for not our class, the majority is accurate to the city. They don't say it's not accurate to the state. So they crafted a very wide report that does not address the issues in our case. So, it's like smoke and mirrors here. And I think that's very important because they haven't shown it's not reliable, we've shown it is, especially since the majority match.
I'm just thinking out loud, but I wonder if geography is actually something that you would prove on a class-wide basis, or if that's just simply like an individual customer's proof of purchase. That's part of the individual claim. Now, you'd have to prove it in a trial for some people, but what you're trying to prove on a class-wide basis is that VTO violates the Illinois Act. Whether it does or not, I have no idea. But geography is just part of an element of an individual's claim.
Yeah. And I think, Your Honor, the way I anticipate this happening is we would try to do both. And it kind of goes into your earlier question, and I wasn't trying to avoid the claim form, is for certain class members, it's not going to be an issue. We're going to have the billing, delivery, IP address, everything lined up.
Oh,
now,
if they place the order, if they live in Chicago, they place the order while they're on vacation in Florida, there's no violation, right?
I think there would be, because this happens. It's not like the Illinois residents. It's just why are you using it in Illinois?
No, they're using it in Florida.
Oh, I'm sorry. I thought they were on vacation in Chicago. I misunderstood the question. Correct. If they're in Florida, that would be true. And then the IP address, would show that. But I understand nibbling around the edges here for a tri-state area, but Florida is not going to be that issue. And at one point I really want to address here is counsel said plaintiffs are not in the data. That is not true. They produced data, the class data, showing plaintiffs. They supplemented and took the plaintiffs out of that. And we raised a big stink about it in trial court, saying you can't just take the plaintiffs out of the class data and then to do an argument. So the first production of the class data, plaintiffs were in there. So I don't think they need to be.
Mr. Keogh, could I interrupt you with one other point that the briefing teed up in a very unilluminating way? You asserted that the defendants used the data to show the state of use. They deny it in their reply brief, and I'm wondering what you're referring to for support of your assertion in your brief about defendants using the data to show the state in which the product was used.
That they track the state information. As part of their business records, they track the IP address as well as, we talk in the separate state, and there's a geolocator information, a state flag too. So their normal business records, they have that information.
And where do we have that in our record, if at all?
I don't recall that site, Your Honor. I can supplement that. I don't have the record site. Point in the record site, I would note that they have a footnote citing to some website that in their brief that was not in the record, that wasn't addressed in the trial court.
They contract, as I understand it, they contract with a third party to provide the IP address connection they have. They capture that. But then they contract with a third party. I don't know the name of it. They would know the name of it. the third party comes in with the kind of locational overlay, if you will, by taking the IP address and then doing geolocating analysis. I think it's those two things that combine that's what they mean by geolocational information, I think.
Yeah, and I think you're correct, Your Honor. But that's just another data point that they have and they retain in their ordinary course of business. And, but once again, we don't just have the IP address. We have the delivery address. We have we also have the former and the old ones too. We have the former addresses. We have the current addresses. We have the addresses of the time the product was used. So, and really, one big point though I don't want to lose is this goes to manageability. By definition, every class member used it in Illinois. And manageability, the circuit court has given much more discretion than the trial court because it has the tools to use, to grapple with these issues. It's bringing this up, the first time in appeal, this is not, I would submit, the place for that. That is for the trial court to sit down and the parties sit down and say, how are we going to address this issue? Amazon, you didn't raise this before, but now you're raising it. How do we solve this issue? Let's get a class administrator in here, these experts who did notice, and let's fashion a claim form that'll satisfy due process and satisfy everyone. That's how this usually works, not after the fact, ad hoc, saying, well, it could be a parade of horrors, and we wanted to depose, we're Amazon, so we have money, so we're going to depose every class member, so you should decertify the class. You would never, that can't be the test. No class can then be sustained if that's the test. And
Okay.
the other address, I'm out of time, so I'll leave the fact that the amount here is not unique. One thing I think is important is they're talking about $60,000 per class member. McGivney, it was $2 million per class member, and they held certification was fine. Cawthron was $17 billion for 9,500 per people. And that's $1.8 million on average. It'll allow us to be higher. So this case is not unique, and if anything, it's on the lower end of damages. But as Judge Rovner pointed out, the court has discretion. It's 1,000 to 5,000. They're stacking maximum possible damages to create a parade of horror that is not realistic.
Okay, thank you very much, Mr. Keogh. Ms. Schuster. We stayed a little longer with Mr. Keogh. We'll give you a couple minutes.
Thank you, Your Honor. I appreciate it. Just a few quick points. First, on the point that the affidavit is an accommodation to Amazon, I just want to reiterate that again, it is not an accommodation to Amazon. It is necessary because that geolocation data is inherently not reliable for the purpose of proving location within Illinois. And again, the named plaintiffs are a very good example of that. Counsel mentions a point not raised in his brief that the data, he says one iteration of the data produced in the district court included his clients. That's a misleading representation of the data. The original data produced was just billing addresses. It was produced later with billing addresses and IP address. By that point, the plaintiff's billing addresses had changed, and none of them ever had an IP address located in Illinois. The only IP address data never reflected these plaintiffs, and so the claim form affidavit is necessary because there are going to be individuals in this class who, like plaintiffs, are not in the data itself, and even if they are, that data is unreliable, as we've demonstrated through the expert. Second, the point that counsel made about there being plenty of tools to evaluate whether these claim form affidavits, these class member affidavits are accurate, it rings hollow because the only specific tool I've heard from the district court or from counsel is that it can cross-check the Amazon data, but the Amazon data is not reliable in the first instance. We've proven that, and they have not brought any data to show that the opposite is true. We've shown it's not 74% accurate to a city, it's 74% accurate, and that's in the best case scenario, to a 100-kilometer radius of a city, and that's a material difference, again, with Chicago being the prime example. And then finally, just to address one last point, the issue of geography, this isn't a question about counting up the sum of damages after liability has been established. Geography is an essential element to liability because you cannot violate BIPA if it did not occur in Illinois. It is an essential element of the claim that has to be proven, and again, the stakes for doing so are very high, and we submit that this predominance problem combined with the high value and superiority problems make this class unsuitable for class 2.
Can I keep you on that real quick?
Absolutely.
Okay. So Judge Hamilton asked a question that at least I heard in substance was saying, okay, at the end of the day, somebody's going to have to prove geography, but why is it necessary at the kind of class liability or at the broader liability phase? Why is it necessary to think of that at that point in time as an essential element as opposed to thinking about it later as part of a proof of claim?
Because it is in fact an essential element of the claim. I mean, as Your Honor pointed out, the parties do not dispute and the courts are unanimous. BIPA does not have extraterritorial
But people will
effect.
come in later in securities cases, will they not? And they'll come in with their trading information, you know, during a class period. But the whole liability phase of it will all be about, you know, the kind of 10b5 elements and not, you know, transaction specific element as information as to an individual plaintiff.
Yeah, but we're dealing with an information privacy statute that deals with individual privacy rights, and the claims are individual. They are personal to each individual plaintiff, and an individual's data needs to be collected, and it needs to be collected in Illinois for there to be liability. The statute is in terms of individual rights.
I don't understand how that's any different from, for example, securities class action claimant having to prove that she bought the security in question in a claims process, or in an antitrust action, a local business proves that we bought from a member of the conspiracy.
It's different in the sense that in order to establish a claim, not just membership in the class, in order to establish a claim, they have to prove that they use this feature in Illinois. Otherwise, it's just not actionable under BIPA, and it's not as simple as
I
a claims
understand your
process.
point. I don't understand why it weighs against class certification.
Because this isn't as simple as a claims process where you would sort of deal with potentially in settlement or after determining liability. Liability is going to be different as to each individual claimant. And the scope of liability, the number of claims, the nature
Isn't
of
that true in the securities case, though? In the securities case, if I'm a member of a class and it comes down to the proof of claim phase, there's liability determination against the defendant, and I'm a member of a class and I come forward and I can't demonstrate that I traded during the class period, I had no transaction during the class period, I have failed at that point. I'm not going to recover a penny.
That's true, but then you're
So
looking
I have, as a member of a class, I have an individual 10b5 claim, but I haven't proven it. I had an opportunity at the claims phase to come in. I came in with nothing.
Okay, but even at the claims phase, and I think this is our broader point, even at the claims phase, we are going to have to put each of these individuals in the witness stand and cross-examine them about where and when that they use this particular VTO tool and whether they used it within Illinois. And that is our argument. Our argument is a predominance problem. This would become an unmanageable class because of individualized issues would overwhelm the litigation of common ones. It's not simply counting noses in terms of what are common questions and what are individualized. This is a big individualized issue combined with the individualized issues in terms of assessing the amount of damages once liability has been established.
Okay, I think we have it.
Thank you, Your Honor.
Thank you, Ms. Schuster. Mr. Keogh, thanks to you, thanks to your colleagues as well for take the appeal under advisement. Okay, our fourth case of the morning comes in Appeal 25-13-15. Fayez Daleh versus the Minnesota Life Insurance Company. Mr. Heilizer? Good morning. I hope I pronounced your client's name correctly. If not, apologies.
May it please the court, Glenn Heilizer for Appellant Fayez Daleh. Mr. Daleh seeks a remand for a declaratory judgment that his life insurance policy remains in full force and effect.
How is Mrs. Perlis doing?
To my knowledge, Judge, she's fine.
Glad to hear it. Okay. What was plaintiff's relationship with her?
I believe the evidence in the record is that he was both a creditor and a friend. He had some sort of social relationship with her, and he also provided her financial assistance.
And was he telling Minnesota Life that she was his mom?
That she was his mom?
Yeah.
That I am not aware of, Your Honor. I'm not aware of a citation of the record for that, but if Your Honor's asking, there must be a basis for it.
There is. Okay, thank you. Go ahead.
Thank you. Mr. Daleh's attempt to make a payment 11 days after the grace period expired was timely, pursuant to the 6-month moratorium on forfeiture contained in Section 234 of the Illinois Insurance Code. In order for Section 234 to apply, the initial question is whether Mr. DeLay's payments qualify as premiums within the meaning of Section 234. The statute itself applies to any premium, installment, interest, or other portion thereof that is required, underscore required, by the terms of the policy to be paid. Here it is undisputed that Mr. DeLay's payments were required to maintain the policy in force. In other words, he only paid when Minnesota Life required payments to maintain the policy. There is the option for planned premium payments to build equity in the case, under the policy. However, the record is clear that when Mr. DeLay acquired this policy, the policy was on a zero planned premium basis. In other words, he was acquiring the policy, he was not making any planned premium payments to build equity. He would only make payments when necessary to maintain the policy in force.
But when you look at the policy, and we see that there's what the policy calls a monthly policy charge against the accumulation value. And part of that monthly policy charge is covering the cost of insurance or the maintenance of insurance. How is that not a premium, just within the plain meaning of the term premium?
It is a premium. We are arguing that it is.
Right, but it's monthly. And then so you run, so that, I think that's my reading of it. Just plain meaning, it looks like a premium, but then you hit the statutory point about if the premium is charged on a monthly basis and there's a monthly charge here.
If I may, Judge,
how is 234 even apply?
The policy makes clear that it's the payment from the insured that constitutes the premium. It says if the accumulation value is insufficient to cover the monthly charges on any monthly policy anniversary, the 61-day grace period begins. You, meaning the insured, may pay premiums during this grace period to cover the insufficiency and to continue your policy in force. And that's why the district court, applying the common definition of the word premium, properly determined that Mr. DeLay's payments were premiums under the common meaning of the term, because it was the payments for Mr. DeLay that served to move this policy forward for some period of time.
So you think that what we need to do is look at the application of 234, 1 and 2 to the specific instance of how it applies when there is insufficient accumulation value in one of these flexible life policies like this, as opposed to, because the statute's obviously not written for a fact pattern, right? It's meant to apply across policies. It sure seems like it's written more with term policies in mind than whole life policies. But nonetheless, we're here.
We're here. The insureds in Louisiana face the same issue in 2 federal cases.
Right, and if you look at the reason I started with that, because if you look at the general operation of the policy, just month to month, looks like by its terms, it says there's something called a monthly policy charge. And the monthly policy charge will, among other things, cover the cost of insurance month to month, cover the risk that's being insured.
Yes, Your Honor, but that's an internal process. We are going to, the insurer is looking at the accumulation value every month. There could be
but the accumulation value, a policyholder has equity in, and then it's reduced month to month.
Correct.
So it's the equivalent of a payment, isn't it?
Section 234 is intended to warn the insured of the consequences of non-payment. In this case, the only warning that Mr. DeLay would receive would be you have insufficient accumulation value in your account, you need to make a premium payment, and it needs to be a 3-month payment. You need to make that payment to avoid the consequences of forfeiture.
So can I ask you, I share Judge Scudder's concerns about that the monthly charges sure look like a premium to me, but I understand other people might disagree. But under your theory of applying Section 234, when did the grace period start here? The moment of default?
That's correct. It starts on the monthly policy anniversary. In this case, it was the 10th of the month.
Okay, so a payment is not made when due. Grace period starts. As I understand the operation of 234, it requires this warning notice at least 15 days before the grace period starts. So you're asking us to interpret the statute to require a notice warning of default and the need to cure it at least 15 days before a default occurs. Is that right?
Yes, Your Honor. I would take issue. Your Honor said a payment when due, but
The 10th of the month.
that's correct. Minnesota Life looks at the accumulation value on the 10th of the month. It determines that there's insufficient accumulation value, and at that precise moment, a payment is due. And Your Honor's asking, how can they go backwards 15 days and serve the notice?
Right.
It's abundantly easy for them to do so because they have all the information they need to do that.
So they're supposed to warn you that you're in default before you're in default.
That's exactly right. The way this policy is structured,
That's a little odd.
the federal courts, as they said in the Turner case in the Western District of Louisiana, this is a fairly new issue. They have the same Section 234 type statute with the same material elements, and we have to figure out how to proceed. But standing here today, I find it very difficult to presume that the Illinois legislature, in enacting Section 234, intended to exclude flexible premium policies from its scope. There's no indication of that, no evidence of that, no reason to presume that.
Well, what
And it
do we
can be
what do we
applied.
make of the exclusion for policies with monthly premiums?
Well, getting to that, and I'll cite the Incandela case just to start in answer to Your Honor's question, because that's a good compare and contrast case. Incandela was actually cited by Minnesota Life in support of their position. They cited the case and said, this case stands for the proposition that flexible premium policies do not fall under the statute due to the monthly exclusion. We attach a copy of the actual Incandela policy to our reply brief and ask the court to take judicial notice of it. And Incandela makes clear that that policy is very different than this one. In Incandela, the payments were actually due monthly. I'm not talking about monthly accumulations of value, any sort of internal computations. Payments were due from the insured every month, and if there was a deficiency, just like here on the date of that default, where accumulation value was insufficient, in Incandela, the policy only required a, quote, sufficient amount, unquote, to make up the deficiency. Not 3 months, as it is the case here, but 1 month.
Why does that make a difference?
Because it takes, the fact that Minnesota Life requires 3 months of payments takes the exclusion for monthly or shorter payments away.
Well, that only applies, though, in case of a default, right? The 3 months worth of payments.
Well, they're calling it a default, but it's also the due date. It's the way they've structured their policy, but
You miss a payment, and to keep the policy in force, you got to come forward with 3 months worth of money, right?
But they haven't missed a payment, Your Honor. And the reason they haven't missed a payment is endorsed on the policy, on the face of the policy, is the fact that my client will not be making any planned advance payments. He will only be making payments in response to notices he receives from Minnesota Life. And Minnesota Life is only going to send notices on that anniversary date. So they call it a default.
But it could be any month, right? The 10th of any month where the accumulation value account is short, right?
Well, once that happens, it's not going to happen again for 3 months because they're going to send a notice requiring 3 months of payments. So unlike in Candela, here, if the anniversary date arrives and there's an insufficient payment, insufficient value, they send the bill for 3 months. If you pay 2 months, your policy is forfeited. It has to
Now-
be a 3-month payment.
Speaking of a notice, Judge Daniel didn't address your argument as to the notice needing to be issued 15 to 45 days before the start of the grace period. It seems to me that there's an explanation for that, which is that the argument was only made in a footnote in response to Minnesota Life's summary judgment motion. So I've been sitting here wondering why that whole argument isn't waived.
Your Honor, we made the argument in our summary judgment memorandum. I actually brought the page. It's not a lengthy argument, but it has its own heading. It's not lengthy because it simply articulates, here's the requirement, they breached the obligation by sending it on the first day of the grace period. But it's fully addressed in our summary judgment memorandum, and I can, when I come back and reply, I'm glad to provide the site.
Okay, I'd appreciate that.
You want to save the remainder of your time?
Yes, thank you.
Okay, you're quite welcome. Ms. Hearing, good morning.
Good morning, Jacqueline Herring on behalf of Minnesota Life Insurance Company. I want to pick up on the court's first concern. This is clearly a policy that's payable monthly. Every month there are monthly charges that are assessed. The one consistent charge listed in this policy is that every month you have to pay your monthly assessment, and it's assessed in advance on the monthly policy anniversary. So that occurs.
May I just get something clear? I know I'm interrupting at a terrible time, but when the accumulation value of the policy first became insufficient to cover the monthly costs of insurance, did Minnesota Life begin invoicing Mr. Dalla on a monthly basis? Or did it otherwise notify him that going forward, he was now required to submit monthly payments covering the cost of insurance? And if not, I'm wondering why we should treat this as a policy requiring payments monthly, such that it was exempt from Section 234.
The policy itself requires a monthly payment. What the court just referred to is how you correct a default in payment. The payment itself is required on a monthly basis. If and when you miss a monthly payment because the accumulation value is insufficient, there's a means to correct that default. But it doesn't change the fact that the payment remains a monthly payment, assuming that you correct your default and the policy continues, because of course if you don't correct the default within the grace period, the policy would end, it would terminate. So what happens is once that notice is insufficient, it's at that point that the policy actually goes into default, and that can be corrected during the grace period, but it doesn't change that this is still a monthly payment that's required. And
I understand the point, but I guess I'm also troubled by the problem that the policy itself seems to distinguish between these monthly charges on the one hand and premiums on the other. So we seem to be having to, your theory seems to require those words to change meaning.
And I think the policy does draw those distinctions, Your Honor, because any amount that's placed in this policy is called a premium, and some of that can go into the investment accounts, and some of that ends up staying to cover those policy charges. So I do think to that extent, But when you look at what the statute applies to, it's intended not to apply to payments that are required on a monthly basis. And the reason for that is once you start giving notice 45, 31 days in advance of a monthly payment, then things just start overlapping each other and it's a problem. And that's another reason why it becomes problematic with this particular monthly payment, because at the time leading up to this December 10th default, the only amount that's due on December 10th is the monthly amount. So notice can't be given in advance of December 10th that as of February 9th you're going to owe 3 months, because you don't owe 3 months until you're in default. So the only thing that's ever owed is that monthly payment until you cross over to being in default. Once you're in default, the means to cure that it is different than the normal functioning of the policy, but the policy itself requires every single month that those monthly charges be paid, and they're assessed in advance on that monthly policy anniversary date.
Can I ask you, Ms. Herring, to explain to us how you think the statute would work if one annual premium is due on this policy, or make it a simple case, just a term policy with one annual premium?
Yes, let's assume the annual premium is due January 1st.
Okay.
So what's supposed to happen is then 15 to 45 days before January 1st, someone gets a notice in the mail, says you owe us $10,000 as of January 1st. It's going to cover you from January 1st to December 31st. You need to make that payment by X date.
No grace period starting yet, right?
Right.
Okay. Okay, and then what?
Yes. And then if the payment is not made on January 1st, well, I would assume that the notice, actually, let me back up. The notice of the payment is going to tell you when your grace period ends. That's how I've seen them.
So in essence, the annual bill has to be the notice that complies with 234.
Yes.
With all of the warnings of termination and forfeiture and so on.
Yes.
Is it kind of, here's what you owe, and if you don't pay it, then you got kind of a grace period that kicks in?
Yes.
But you'll have a grace period of X days or months from January 1st.
Yes. And it's typically, I think the statute for life insurance requires 31 days, and 31 days is a typical time period. I think sometimes that's varied a little bit depending upon the term that's being covered. But yes, that's what you're typically going to see.
Do you all see a lot of situations like this where investors have bought insurance policies and then kind of skate at the edge of default?
When investors buy them, that is what we see.
Can I ask you a question? It's the kind of square peg, round hole question that Judge Hamilton was getting at, and that is, I think I follow every argument you make in your brief, except one. And the one that I don't follow is the point about the 15 to 45 day notice, how the notice here complied with that requirement. And the reason I say square peg, round hole is it for the same reason that was implicit in his question. I don't know how that is to be administered in a situation like this. But when you just look at the fact pattern, it sure does not look like you sent it out at least 15 and up to 45 days ahead of time. So what's your argument? Forget whether it's right or wrong. Right. What's the argument?
The argument was in response to what counsel raised, that if we're going to be looking at this February 9th date as the date the payment is actually due, what the statute requires is the date before the payment is actually due, you need to give your notice 15 to 45 days in advance. And that's part of the problem we've got with the monthly payment.
But that's a response to the point he's making. We know that the payment was due on December 10th of 21, right?
Yes.
Okay, so the only way that you can comply is to rewind 15 to 45 days before that date. And we know, as a matter of fact, that there was no notice go out.
That's
now,
correct.
You've got a whole bunch of other arguments
Yes, and if we all agree that December 10th is in fact the operative date, then that's a monthly date that wouldn't require the notice, and I think that's why it ends up being, I'm not arguing that the notice that went out occurred 15 to 45 days before December 10th, if that's the court's question. I was trying to address the concept of if we're going to allow...
But that's not what the statute requires, even though it's odd?
It is what the statute requires, but not on a monthly payment. And that's why, and I'm not explaining myself very well, I'm not arguing that the 15 to 45 days occurred before the December 10th payment. What the argument was intended to be is if you buy into plaintiff's argument that the only thing required is the February 9th payment, that 15 to 45 days before the February 9th payment was when the notice went out.
That's how you're interpreting due and payable.
Based on their argument.
All right.
Yes.
Okay.
Because again, we don't agree that February 9th is the correct date, but if that is going to be viewed as the operative due date versus the December date, then it's within that 15 to 45 day window of the February 9th due date. And that's again sort of the problem with addressing it in that way, because that February 9th payment isn't a payment that's required by the policy. That is the payment that is fixing your default. The payment that was required by the policy was the monthly payment on December 10th. This February 9th payment is how you cure once you're already in default, once that grace period has already started. And the statute does not require 15 to 45 day notice of every monthly payment. That's why the monthly payment policies are exempted from the statute, because it does create that problem with overlapping. And again, the purpose of the statute is so that when someone who has their annual premiums, they don't just forget, and then their policy immediately lapses. But if you're paying on a monthly basis, you don't need a 31-day reminder that as you're paying today, you got another one in 30 days, you got another one in 30 days. Or if you're doing a 45-day reminder, then you're giving notice of a payment that's after the next payment that's even coming due. So it doesn't make sense, and that's why the statute specifically exempts the monthly payable policies, which this is one of those policies. It's very, very clear in the policy that charges that are required to be paid on a monthly basis, assessed in advance on the monthly policy anniversary. The statute simply does not apply to this particular policy. He was given the opportunity to cure his default in payment, and he did not pay before the February 9th due date. And the policy, therefore, terminated as of that date.
Before your time is up, I don't know that this is a core issue, but can I just confirm, separate and apart from the deposition testimony that I think it's the son, somebody named Gus?
It's his son.
Okay. Gus Dalla?
Dalla.
Okay. Separate and apart from his testimony that he made a payment, his statement that he made, is there any evidence at all of a payment being made? Were there copies of check registers,
Nothing.
the copies of cleared checks and a gap in the cleared check list or something like that? Anything?
Absolutely nothing at all. He couldn't even say whether he supposedly sent the check from California or from Illinois. So absolutely no indication that any payment was paid, other than, yes, he did testify that a payment was made.
And they had on
That one was mailed.
That one was mailed.
and on this kind of investor skating the line point, these folks had been they'd been in grace period payment mode for a while, right? So,
yes.
and somehow, some way during the grace payment period, they made a payment, whether they did it by wire or check, or somehow they paid.
They never paid by check. It was always either a telephone call or an EFT online payment.
Okay, so
There was never a prior payment by
the
check.
family was aware of how to pay.
Yes, and he would typically call to say, hey, I made an online payment yesterday. Did you get it? Is the policy still in effect?
Okay. Is that part of the record, or are you just saying that?
That's in the record.
Okay.
How many times had that occurred?
Several. I know in the brief, I only went back to, I think, 2020 and 2021, but on page 13 of our brief, I've got a chart that lays out 1, 2, 3, 4, 5, 6, 7 different dates. The first of which is December 10 of 2019, and then 3 dates in 2020, 3 dates in 2021. Those payments were all made either by telephone or online. And other than the September 10th due date, the payment dates were the last day or a day or two before the last day. And we laid that out in the chart.
When you say by telephone, do you mean that he would say, this is my MasterCard, charge it, or I'm not, how do you do it by telephone?
Yes. Gus would call, the son Gus would call, he would say, my name is Fayez Delay, my date of birth is XYZ, and here's how I'd like to make a payment on this policy on which I am the owner. So the son would call and represent himself to be Fayez Delay, and then, yes, would make the payment by telephone.
But with what?
Oh, yes, a credit card or an EFT. I don't recall, so I don't want to say one or the other. But yes, you can do an EFT. Here's my bank account information, okay. And you can take it directly from my bank account. I believe these were EFTs and not credit cards. And that's more typical. Someone calls up with their bank account, and that's how it's done. Or actually, online is probably the most typical, but when you're on the last day, if you do it by phone, then you've got a person who can confirm for you, yes, we got that payment and it was done. So this policy terminated by its terms on February 9th of 2022, and the district court correctly entered judgment for Minnesota Life, declaring that the policy is terminated. Thank you.
You're quite welcome. Howleiser, I think you had some time. Yep, you got some time left.
Judge Rover, in response to your question about raising the 15 to 45 day issue in our summary judgment memorandum, it's document number 35, page 11.
Thank you.
The heading is subsection B. Taking one of the latter points first, we don't intend to argue the factual issue rising from my client having mailed the check. However, we'll rely on the briefs. However, counsel says there was no evidence of payment in response to a question from the court. There was a specific question about a statement with a gap in checks that may or may not have been produced, and she said it had not been. There was a statement showing a gap in the check sequence that was produced.
According to his testimony, right? That I don't want to get. I think
Okay.
This is a side issue. Keep
Very
going.
Well, I'm sorry, you've raised it.
Yes.
Where did you tell the district judge this was a reason to deny summary judgment?
We didn't address this at all. We didn't address this issue at all because Minnesota Life didn't raise it. In our papers, we took the position that this was a factual issue, so we were not seeking summary judgment on it.
That's not my question. Where did you tell the district judge that a factual dispute about whether this payment had been made and received required denial of summary judgment?
We didn't do that other than to raise the issue in our statement of material facts.
Okay, so it's not in your brief. I didn't see it in your brief. You're telling me it's not there. Thank you. Okay.
And there was no response to that, is what you're saying.
Correct. It was not raised. So Minnesota Life was the party seeking summary judgment on the issue of the mailed check. We were not seeking summary judgment in our favor. We felt it was a factual dispute. Minnesota Life, they recited in their statement of facts that they had not received the check, but they never made any argument whatsoever in their papers that they should prevail on summary judgment on that issue, so we didn't respond to it. Counsel said several times that the policy requires monthly payments. There's nowhere that this policy requires monthly payments. It's only 3-month payments that's required. I believe my time is up.
Okay, very well.
Thank you.
You're quite welcome. Mr. Howleiser, thanks to you. Ms. Herring, thanks to you. We'll take the appeal under advisement. Judge Rovner, mindful that you're remote, I just wanted to check online. Would you prefer an additional break, or do you want to go forward with our fifth case?
That is so kind. I would like to go forward.
Okay. Judge Hamilton, you're good? Okay. So we'll go forward with our fifth argument of the morning. It's in appeal number 243164, Maria DeFranco versus the City of Chicago. Mr. Shoup, I see you. Nice to see you. And then Mr. Collins. Yep.
May it please the court, Dublin Scope on behalf of the estate of Marco DeFranco, Your Honor, panel, the Chicago Police Department is a paramilitary organization. It has officers that have ranks, the chain of command that gives orders. Those orders are not suggestions. They're not aspirational hopes. In March 2020, in the wake of the COVID-19 pandemic, CPD enacted a Special Order 04-09. It was an accommodation measure. It was a recognition that there are officers in the police department that were at high risk of contracting a serious illness and death from COVID-19 if they had certain underlying medical conditions. Marco DeFranco was an undercover narcotics officer who did have one of those serious conditions. He had cystic fibrosis and cystic fibrosis-related diabetes. On March 19th, 2020, consistent with Special Order 0409, the Chicago Police Department advised all officers at risk, all officers actually, that if they needed or wanted an alternative work accommodation to make sure to reduce the risk of catching COVID-19, submit the paperwork. Within 2 hours of that special order going out, from the notification of the special order, Detective DeFranco complied. He submitted all the requisite medical paperwork to the medical section. The medical section's Dr. Susan Arjmand, reviewed the information, realized that he qualified for an accommodation, forwarded it to the CPD Human Resources Director, Robert Landowski, and Robert Landowski never responded. 2 days later, and we know that because Chief Landowski testified. He saw the paperwork for the first time when he was sitting in his deposition. He realized that there was no follow-up from him or anybody else at the medical section directly engaging Officer DeFranco, Detective DeFranco. 2 days later, on March 21st, Officer DeFranco sent in a self-certification for following up on the request. Again, nothing in his medical record, nothing in his medical file showing that CPD followed up. Director Landowski admits that that's the case. Dr. Arjmand admits that that's the case. And the city's risk manager, the Chicago Police Department's risk manager, Michelle Morris, they all said there is nothing in the record that says that there was any follow-up. Nothing. Now,
Forgive me, Mr. Shoup, whatever questions you've raised about the March 19th COVID exposure report that Sergeant Vinnick completed, I take it you do not dispute that Mr. DeFranco was, in fact, exposed to COVID on the morning of March 19th, and you have not documented any other workplace exposure that might account for his illness and death. So what I am trying to figure out, and I know you'll help me, in what sense could any error or delay in the city's response to the accommodation request have harmed Mr. DeFranco?
Judge Rover, I want to thank you for that question because I think that's going to help us get right to the point here. What I will agree for the rest of this case, hopefully when we go back down to trial, is this, that there's no dispute from the plaintiff's perspective that Marco DeFranco definitely contracted COVID-19 while he was working for the Chicago Police Department. The police department admits it itself. Well, our point is that there's a question of fact about when specifically did it happen, okay? It could have happened, from our perspective, it could have happened sometime on March 19th, 20th, the 21st, the 26th, because proximate cause is a question of fact. And the only thing that we know about the March 19th timeframe is what we know from the Vanek, what I would refer to as the Vanek authored exposure reports that didn't even exist until April 2nd, 2020, after Marco had already died.
So the options are, you disagree with Judge Rovner that as to the 19th.
I'm not saying...
You're just saying there's an open question. It could have been the 19th, but it could have been Friday the 20th. It's not likely it was 22 or 23 or 21 or 22 because he didn't work. That was a Saturday and Sunday.
Right.
Monday was the 23rd.
Right.
And he was in the shop on the 23rd.
Yeah. So I'm saying that he was on duty definitely on duty on the 19th.
Right.
Judge Scudder, what I'm saying is that a jury, 12 people could sit in the room and they could say, listen, given the circumstances of the creation of this document, and given the when I'm saying the document, I'm referring to the exposure report that says March 19th and 19th.
I know what you're talking about.
Right. So that Vanek had literally sat there after talking with Sanchez.
Well, the thing that's odd to me about your argument, or I just want to try to break through a little bit, is that I don't think there's any question that the document is backdated as a matter of fact. No, but I don't read the city to be saying, in fact, it was filled out on the 19th. No, it was definitely filled out later.
Right.
Okay. But when it was filled out later, it has, I mean, we have it in front of us. Right. It has that little narrative in there about, what's his name, Vanek?
Yeah.
Sergeant Vanek or something? That what his belief...
Then Sergeant, now Lieutenant.
Okay. Mr. Vanek, as to what his belief was as to when, because he had some awareness of what your client did at the station house on the 19th. But it's definitely filled out after the fact.
Well, yeah, but it's all, well, yes, no one's disputing it was filled out after the fact.
Right.
But what I want to also make sure about this is that it was filled out after the fact, knowing that he was already dead, knowing that no one had followed up on the reasonable accommodation request earlier, which means, that's our argument,
right?
And which means that he had free reign to decide what time to put on that document.
Okay, the reason I wanted to ask that, what's the, step back from the fact pattern.
Okay.
I know it's a tragic fact pattern. There's no question about that.
Right.
Okay, but step back from the fact pattern. What do you believe the law requires when it comes to whether an employer has acted timely to provide an employee with a reasonable accommodation under the ADA?
I missed the first part.
Okay. What's the legal standard measuring the timeliness of accommodation? What's the ADA require? How do you articulate that standard?
I would say in this circumstance, Your Honor, that if the city had tried to make some attempt under these particular
forget this fact pattern. If we had to write an opinion, okay, and whoever has to draft the opinion comes to that sentence where we have to type it down, is to how do you figure out whether an accommodation was timely? Because I would think that timeliness of an accommodation is part of the reasonableness of an accommodation.
I think it really depends on the particular circumstances. And here, when you know that you're dealing with a high-risk individual... Okay,
so that's the standard, just the reason... Is that what you're saying? Reasonableness of the timing.
It's the totality of the circumstances, so it's going to be how soon do they respond given the emergent circumstances of the situation.
Okay, do you know of any case law on this?
Your Honor, no.
I mean, I don't think there's much out there, if any.
And Your Honor, I've got 2 minutes.
We're going to give you time. Don't worry about it.
Okay.
Okay. Anything else you want to say in response to that?
I think it's multiple things. I think any employer would have to figure out, okay, what are my circumstances? What is the nature of his condition? What are the nature of his job duties? What's he actually doing? There's high risk and there's high risk. Are there certain things that we're trying to figure out on a temporary basis to make sure that he's not going to be exposed? For example, his normal internet duties when he's doing these covert buys is to go to Home and Square. Okay, well, can we make sure he has to go through one specific location until we can figure out what we're going to do with him? Can we do this? Can we do that? We had to troubleshoot, but that's the whole point of the interactive process. You have to engage the individual, talk to them, figure out what works, what doesn't work.
Well, that's what they were doing on that Monday, I thought.
No. No,
What do you-
this is what I mean by that, Judge, is this, and that's why I started with there is a very regimented process. They had that there were only two people that really could have engaged with this process. That would have been per CPD's rules. That would have been his commander, Commander Kimball, and then also been Director Landowski and Chief O'Donnell for the medical section. Those two would have to talk to Kimball with Marco to figure out an actual accommodation. That was their rule. That was their order. That's what S0409 required. The city said it's no big deal because if we don't follow our rules, because Vanek talked to him later or Sanchez talked to them later. Neither of those individuals had authority to give Marco anything. They could have said, Marco, we'll give you this, we'll give you that. It had no binding effect within the Chicago Police Department per their order. There were only, literally, Your Honor, and I'm not exaggerating, Director Landowski said this.
Well, hold on. I thought in one of those meetings, don't worry about the clock.
Okay,
All right.
I'm listening.
I thought in one of those meetings, maybe more than one, I have in mind Sanchez and is it Sergeant Vanek or Lieutenant Vanek?
At the time, Sergeant.
Okay.
Yeah.
That they recalled your client saying, no, I've worked this out with Vanek. And the workout was, we're going to single car surveillance, and I'm going to be out looking at the lakefront or Millennium Park or something.
If I may, Your Honor, because this is the part where the fact pattern and the conflicts materially go all over the place. So per Commander Kimball, who was the only person that was authorized to really give my client's husband an accommodation, his version of events was on March 23rd, suddenly and spontaneously, Officer DeFranco walks into his office, is worried to death, scared to death, and almost to the point of tears of dying of COVID, but then suddenly says, and then that's when Commander Kimball apparently says, go off to the medical section. Although Kimball says, maybe I did, maybe I didn't. He sort of waffles.
Yeah, the medical section is Sanchez.
Sanchez. The same day, the very same day, on the heels of that conversation with Kimball, Marco goes to see Sanchez, and we know that it was on the 23rd. The version that Captain Sanchez gives is that Commander Kimball ordered Marco to go to the medical section to seek an accommodation. Okay. Well, if he'd already gotten an accommodation he was happy with, the commander would not have sent him to the medical section to do it. More importantly, because they all later say, well, he was given this accommodation by guarding the beach over at Lakeshore Drive, which was the infrastructure that Marco was allegedly protecting. If that's the case, and if that had truly been given to Marco as an accommodation, as part of some interactive process, then it would have been documented. It wasn't documented, Your Honor. And that's what everybody kept saying. It had to be contemporaneously documented.
Mr. Shoup,
Yes, sir.
I want to see if I understand this correctly.
Yes.
Is there any affirmative evidence that plaintiff was exposed to the COVID virus after March 21st?
Well, we know that, I don't mean to be curt, Your Honor, but obviously he passed away from it, and then the city applied the rebuttable presumption under the ODA.
Well,
Yeah.
there's the rebuttable presumption, I assume, provides additional benefits to the family, correct? For death in service? Course of duty?
It's more of a city of Chicago Police Department situation about what he would be or would not be able to. So the ODA was, I'm sorry, I want to make sure I understand your Honor's question.
Keep going.
Okay. So what happened, Your Honor, was this. When after Marco had passed away, the awards committee has to decide whether they're going to designate his death as a line of duty death or not.
Right.
It's an ad hoc committee. It only meets when officers die. So they met on April 2nd, 2020. In anticipation of that meeting, they usually get all of what would be the relevant records. Okay. So when an officer dies, they usually get autopsy reports, injury on duty reports. None of those documents existed when Director Landowski reached out to the medical section to ask to figure this out.
Okay.
So they didn't even have the exposure report. So based on that situation, they, according to the city, relied on a rebuttable presumption in a statute that didn't even exist until 2 months later.
Look,
Okay.
let me try to cut to the chase.
Yes, sir.
I understand We've got conflicting stories coming from defense witnesses.
Yes.
I'm looking, though, for affirmative evidence that would support a reasonable conclusion of proximate cause of his death after the 21st.
Your Honor, my position is the exposure could have happened on the 19th after the first request was submitted, and that because that happened on the 19th while he was still on duty, but the symptoms didn't manifest until the 21st or the 23rd or the 26th. Well, he definitely falls by the 26th, but there could be subtle symptoms before you take the big fall. So.
Okay.
Did you say that in the briefs? Did you say that in the briefs?
Excuse me, Your Honor.
Did you say what you are saying now in your brief?
We argued the proximate cause issue as a question of fact, Your Honor, in our underlying summary judgment motion and in our opening brief. When the
I understand you asserted that. Is your theory now that Detective DeFranco was exposed to COVID on the 19th of March after he had requested an accommodation?
My position is a jury could reasonably conclude that, yes, Your Honor.
But is there any other theory that gets you to proximate causation that is somehow the police department's fault?
Yeah. It could be the 19th. It could be the 20th.
He's not on duty the 20th and the 21st.
He's not on duty on the 20th or the 21st. Okay. He does submit the certification on the 21st. He also then reports to duty on the 23rd, still packed up. So which means that if he could have gotten
I'm trying to get to the point of whether you've got affirmative evidence to any of this effect, or whether you would just ask a jury to be sympathetic and speculate in your favor.
It's called a reasonable inference, Your Honor. So I'd say,
How?
because the city admits that he was on duty on the 23rd, which is after he submitted the second request on the 21st, and after he submitted the first request on the 19th. So when all the paperwork purporting to establish the existence of accommodation is documented.
And what happened to him on the 23rd that put him at risk? Was it just being in the meetings to request the accommodations?
And going to Holman Square, the same location where everybody's around each other, yes. Because the whole idea of the
I'm trying to, my problem is, as I understand it, the wrongful death claim, you need to prove not just negligence, but willful and wanton misconduct.
Right.
And I'm having real trouble getting there.
The source of the willful and wanton misconduct, Your Honor, is the notion, our position is that you can reasonably infer that when you create documents that are internally inconsistent about what people actually said about what truly transpired, that's evidence of consciousness of guilt that they didn't do what they were supposed to do, and now they're trying to conceal the fact.
Okay, that's your theory.
Yeah.
Okay, thanks.
We'll give you a couple. We used a lot of your time. We recognize that. Okay, you'll have a couple minutes for rebuttal. Don't